Conservancy, Science, and Education. We are located in Hopewell Township, so come see us if you are in the area. We have a great number of speakers, but let me do some webinar logistics. We are recording this. Let me repeat that. We are recording because someone always asks whether we're recording. And we will send you copies of the presentations in about a week or two after the webinar. If you have questions, there is the Q&A aspect of Zoom. Please put your questions in there. We will take those questions at the end. I appreciate everyone for participating. If you are an attorney, we are a certified legal education provider. We will be providing a verification form. Please fill that out. We will be giving codes during the webinar. You must stay for the entire webinar, and you must complete the verification form to get your CLE credits, and you must pay for the CLE credits. All right, in no particular order, our speakers, it's not actually in the order of presentation, but Michael Sinkovich is a shareholder for Lieberman Blecker, practices environmental and land use. He has provided his expertise to us in the past, for past webinars. Mark Gallagher is an environmental professional, founder of Princeton Hydro, and oversees wetland and terrestrial ecology projects. Again, Mark has done multiple webinars for us. And for those of you who do not know Michelle Donato, you have missed out. Michelle Donato is, her bio is right in front of, behind everything, but she represents planning boards in the borough of Roosevelt and Allentown. She represents municipal agencies and developers. She's general counsel of the New Jersey Planning Officials and past president of the New Jersey Institute of Local Government Attorneys. If you have not seen Michelle at a planning board cross-examining an applicant's experts, you have missed out. She is fierce and has a wealth of knowledge. So with that, I'm going to turn this over to Mark, who's going to sort of set the stage on the status of our natural environment and why municipal ordinances are so important. And then I believe, Michelle, you're going to talk about planning and zoning and definitions, and Mike is going to bring up the rear and talk about actually crafting some of these ordinances so we can better protect our environment. So with that, Mark, thank you very much, and I'm going to stop sharing and you can.
Can you see it?
Yes.
Good. Never quite sure. Hey, first I want to apologize in case I start to cough. I'm just getting over a cold, and possibility of a little coughing attack is probably going to happen at some point. Anyway, as Mike said, I'm going to talk about somewhat the status of our existing natural green infrastructure. And I want to use that term instead of just, specifically talking about environmental features of our landscape, because that's the term we use for stormwater management now. And in the state and federal government's context of green infrastructure, they tend to focus on engineered features that mimic our natural green infrastructure. But it is our natural green infrastructure, things like forests and floodplains and riparian zones and meadows, that provide all those services that we try to mimic with our engineered green infrastructure. So how we manage our natural green infrastructure is essential to healthy watersheds. Sadly, most of our current natural green infrastructure and streams are degraded. For example, ideal floodplain connections are uncommon. Most of our streams in developed landscapes are disconnected from their floodplain. And I say disconnected, I'm referencing more how frequently those floodplains should actually flood. Instead of, there's some streams we've studied, it takes a 10-year event for the water to actually leave the channel and go into the floodplain. And well-conceived municipal plans and ordinance are essential to maintaining our existing natural green infrastructure and our streams. But knowing these ordinances are designed more for land development, it really is trying to strike a balance between how we can navigate development applications and still do the best we can to maintain our natural areas. And some key municipal documents are master plans, which in general provide a vision for the future and how to guide development and open space protection. Master planning elements for open space are also important. How do you identify those areas that might be best suited for acquisition and prioritizing those acquisitions? Environmental resource inventories. One of the things I found over the years that many towns, those resource inventories are buried. People don't even know where they are. Digital versions that can be used online now probably are one of the most advantageous ways to present a municipality's environmental resources. Easy to find, not a document even, it's just an online service, and interactive ones are all that much better. Natural resource protection ordinances. Pretty much every town has some ordinance that guides the protection of environmental features like steep slopes and woodlands and wetlands and floodplains, stream corridors. And a good environmental impact statement ordinance is also good. I will take a step a little broader. So in the 70s, the Clean Water Act was enacted, and it was really the goal that the discharge of pollutants in navigable waters would be eliminated. And we were seeking to maintain water quality in the entire country. And in New Jersey Water Pollution Control Act, policy of the state to restore, enhance, and maintain the chemical, physical, and biological integrities of our waters, protect public health, safeguard fish and aquatic life, provide or maintain scenic and ecological values. And I'm sure everyone on this call has some way interacted with all the regulations that New Jersey has to either protect wetlands or, guide management of floodplains and stormwater management, surface water quality, and the development of ordinances at municipal levels. But then the question is, how are New Jersey's watersheds and waterways really doing? Sadly, healthy streams in New Jersey are not very common. They're pretty much limited to those less developed parts of the state, like this one in Hunterdon County on the Wickichiokie. And it's not the entire stream. Even parts of that stream could do better. The Flatbrook is probably one of the healthiest streams in New Jersey, but it's in a landscape that's virtually undeveloped. Alternatively, we have done a lot to degrade and manipulate streams in New Jersey. The Elizabeth River is probably the most obvious example of how we manipulated a stream, completely separating it from any natural green infrastructure. Pipe streams. Now, these are pictures from Philadelphia, but New Jersey still has many pipe streams. filled floodplains, probably the most common feature. And this is just the Petty's Run in Trenton, and both sides of this channel were filled. And a lot of this goes back to our view of streams. Prior to understanding the values that they provided and the value of floodplains, this is an advertisement from the 30s that, to me, just really highlights many of the injustices that happened in our streams at this point and later. Just saying this sentence, that crooked streams are a menace to life and crops in the areas bordering their banks. In the advertisement, DuPont Dynamite has straightened thousands of miles of crooked streams. And this is just an example of a stream in Raritan Township near Flemington. So the red line that you see here, that was the original stream channel from the 30s. And then the yellow line was when we improved it to be a straight channel. And since that time, the blue line has been trying to find a more natural pattern to slow that high velocity flow down and to meander and just find a grade that makes it more of a stable system. But since it was straightened, the stream has widened, it has deepened. The banks are now 4 to 5 feet high. It meanders quickly after storm events. And the conversion of natural areas to development features, be it impervious surfaces or lawn, and areas like this and compacted lawn generate similar amounts of runoff to impervious surfaces. All these together, the loss of our natural green infrastructure and conversion to features like this, all stress our streams with excess stormwater volume. So when we do watershed management plans, one of the probably characteristic of the results of all those studies is related to the volume of stormwater directed to streams and the increase in pervious cover and lawns. All of it result in the degradation of streams. And that could start as little as 10% impervious cover. So from a watershed perspective, increased volume of stormwater is one of the most destructive attributes of stormwater associated with developed watersheds. Increases volume, increase the magnitude, frequency, and duration of bank full flows. And these are the changes that lead to widening and bank instability, increased sediment loading. And one of the streams we studied in central Jersey found that the bulk of the suspended solid load wasn't from development. It was in-stream erosion. So because of the deepening especially, there's less interaction with their floodplains. And that compromises floodplain functions. And healthy green infrastructure, those floodplains, are what foster slowing flows down, fostering sedimentation, and in some drier floodplains, increasing infiltration. So how do we deal with the overall effect of these degraded stream systems? Now, as I said, ideal floodplain conditions are uncommon. And the other thing is those temporary storage, where those flows are slowed, and it reduces the amount of water and how quickly it gets to those poor communities at the low end of a watershed. The nutrient retention helps reduce the sediment loading to water bodies, be it a lake or an estuary like Barnegat Bay or Delaware Bay. Fosters infiltration, and it maintains our biodiversity. I'm going to go through some examples. I mean, this is a stream channel, and you could see how narrow the actual channel is. But because of all the excess volume, it's deepened and widened. Just another example, and some of these streams do not flood, and naturally they should flood somewhere between a 1 and 2 year storm event.
Recording
Any
in
of
progress.
these. Michelle?
Yeah, I'm here. I'm getting off of the online because my internet, I'm muted. I'm getting off of the internet because it is unstable. It keeps giving me a notice. I switched to fire, so thank God to fire. So I'm gonna just do phone.
Okay. So just another example of widening. And all those roots that are hanging out in the air, roots don't grow in the air. That's just an example of how much sediment has been lost and moving downstream to some receiving body. Just another example of sediment loss and bank instability. And again, all those roots, they did not grow out in the air. This is a way to look at how much sediment has been lost over a short term. Just some other examples of just severe erosion in, developed watersheds. It is not uncommon. And this goes back to Walnut Creek when I showed you that stream that was straightened at one point. This was prior to some restoration efforts to stabilize the stream and reconnect it to its floodplain. So the photograph in 2005, you can see all the massive slump blocks sitting in the stream channel. But one of the things to note are those evergreens in the center of the photo. By 2009, the stream moved 23 feet and those evergreens were gone. Just another photo of Walnut Creek, and this is an example of a stream that took almost a 10-year event to actually get out of bank and water into the floodplain. One of the other issues is related to undersized culverts. These can cause massive amounts of erosion down gradient. And it's one of those topics that it's related to increased volume of runoff, some of it related to just increased severe rainfall events. And the question is, why should we care? And what can we do? And one of the issues I mentioned before is by keeping all that water out of the floodplain, at some point downstream, that water is out of bank, causes nuisance flooding and severe flooding in some communities. And because they're at the bottom of the watershed, there's not a lot they can do to solve their problem. And this is a watershed-based issue that the further up in the watershed we can better manage stormwater, it's better for everyone living in the watershed. One of the things that we don't hear much about, but is a major research topic that's going on right now, is that much of our marsh subsidence is attributed to excess nitrogen in the bays and the estuaries. So when you look at a wetland like this, all these little islands, and if you can see my cursor, but like a little island like this, it isn't that Spartina just had a little high spot to grow on. All this water is the marsh that has disappeared. It's too wet, it subsided or eroded away and is gone. And part of bank slumping isn't just attributed to boat wakes. It's because the nitrogen has weakened the strength of the marsh to actually hold the marsh in place. And that weakened marsh is more easily impacted by boat wakes. Harmful algal blooms, directly related to excess nutrients. And a lot of that is all because there's so much erosion in the watershed. It gets to a receiving body and helps the eutrophication process. Excuse me. Increase need for maintenance dredging of small receiving bodies like ponds and lakes. So what can municipalities do? One of the things is to just really look at their ordinances. And what I've seen with some towns, they believe that New Jersey DEP stormwater rules are comprehensive and they don't need to do anything more to protect their watersheds. And that's something that they should not think that way. There's always things that a municipality can do that would benefit watersheds, that would supplement DEP's regulations in a way that could make their watersheds healthier. So I would encourage you to check out model ordinances, such as the ones that the Watershed Institute developed, as just a first alternative to seeing what you can do to better manage stormwater in your watershed. And look to other towns. Some towns have some interesting ordinances, and one I like is Reddington Township's stream corridor ordinance. And many times you don't have to kind of benefit your watershed just through stormwater ordinances. There's a lot of different ways to help reduce runoff and to better manage your municipality's green infrastructure. And one of the opportunities I see in the future is when when each municipality has to develop their watershed improvement plan, to take a more holistic view. Don't limit it to BMPs such as rain gardens and basin retrofits. Include other things. You can include ecological restoration to fix some of those stream channels that we saw in those slides before. And for some towns, a stormwater utility may be the answer. But one of the best things any municipality can do is just make sure applicants fully comply with the ordinance. And this is an example. That body of water is an infiltration basin. They're supposed to be dry in 72 hours. And that same site, there's fishing lures. There were bait boxes. People are fishing in an infiltration basin. That is not a good sign. And the solution? All they needed to do was question the soil probes that were done, because this whole basin was underlined by clay, as shown in this photograph. Going to go back to Reddington Township, because they have their stream corridor ordinance. And they had an affordable housing project on a redevelopment site. As part of their developers agreement, they had them remove the historic access road and reconnect the stream to the floodplain. That was a simple ask that I don't see often enough. It was a redevelopment plan, and rather than just look at the footprint of the proposed development site, they applied their whole ordinance to see what they can do to better the watershed at the same time as approaching this as a redevelopment project. Hopefully none of you have to encounter what West Orange is dealing with. They were sued and in a settlement agreement with a developer for 496 condo units on a 120-acre property located on steep slopes of the second Watchung. The settlement agreement states the tract shall be exempt from all bulk design and environmental regulations. They voided the steep slope ordinance. They voided the need to do an environmental impact analysis. And they modified their woodland clearing ordinance to something that does very little to protect what's left of this forest. But on the flip side, Bloomfield had a different approach. The developer was looking to build in the floodplain. Town fought it for years. DEP certainly wasn't happy with building a townhouse community in a floodplain, but ultimately they did obtain township approval and DEP approval. Town went ahead and bought it. I'm going to go back quick. This site was already under development. You can see in these photos, they even had the sales trailer up. Township bought it, converted it to open space, and then the area to the north, through the help of DEP funding through the Wetlands Mitigation Council and Natural Resource Restoration, they created 4 acres of floodplain wetland to add to their natural green infrastructure. And this is in a very urban area that most people say this can't be done. So I give a lot of credit to Bloomfield to make this happen. Anyway, thank you very much for your time.
Thank you very much, Mark. A lot of great stuff there. And as Michelle is pulling up her slide, so Mark, if you would stop sharing, I will give the attorneys in the room their first code, 1972. That is 1972. Bonus points if you know what 1972, why I picked that. And as Michelle's pulling up her slides, let me just also, Mark sort of teased it a bit. Why should we care? Why is this important? And I will sort of reinforce what Mark was a little bit talking about. So all towns have to do watershed improvement plans, how to reduce flooding, how to improve water quality. Ordinances, planning and zoning, as Michelle is going to talk about, and Mike Sinkovich, can all be part of it that helps us get to the end goal in a way that takes advantage of opportunities versus costs as we have to build things. All right.
So Mike, I did not prepare slides and I didn't know you were expecting them,
Okay.
but I will be sending over 3 articles that cite to various case law and
great.
different provisions of the MLUL.
Great. All right. Take it then, Michelle.
Okay. So Mark Gallagher is a very tough act to follow. As a scientist, he has a tremendous hold on the nature of regulatory law. And so he is really able to give a very broad and very comprehensive approach to the problems that we confront. So I have concentrated in my career in developing land use ordinances for municipalities who wish to preserve the environmental features in their community and limit development based on the carrying capacity of the land. Not every piece of property should have the same yield. And for many years, it was thought that the land use law did not allow municipalities to enact ordinances that created different yield for properties in the same zone. They thought it violated what is the uniformity clause of the municipal land use law and its predecessor planning statutes, which stated that the zoning provisions had to be uniform throughout the district. And this held sway for many, many years, precluding municipalities from adopting definitions and ordinance procedures that would appear to differ from the language of the municipal land use law. And fortunately, in 2003, the Supreme Court of New Jersey took 2 cases on for review that addressed this topic and very clearly and quite comfortably provided guidance for municipalities that clears the path for the enactment of ordinances that create different density and floor area yields based on the physical characteristics of the property. It is one of the most important tools that municipalities have. We often hear complaints about New Jersey and the number of municipalities we have, the fact that we have home rule, and it's such a terrible thing. But actually, home rule can be a blessing. And it can be a blessing because it allows the municipality to actually look at its own town and create an ordinance that is suited for the properties in its town. And as Mark pointed out, to really be able to control what you're going to have in the future. And it can do so very legitimately. And I'm going to have posted for a distribution with this event, the summation of the cases that I'm referring to from the Supreme Court. It was Rumson Estates and Ferrara Builders, and they really do provide an enormous opportunity. And it's important because not every town has the resources to individually analyze the yield of a property and all of the properties throughout the town. By enacting density and floor area ratio ordinances that subtract out environmentally sensitive features from the yield, you have essentially transferred that obligation to the developer, and the really fundamental principle of planning law, which has been unfortunately ignored more than honored, is the idea that each property has a certain yield. Not everyone should get the same yield. So what has happened, instead of really differentiating property based on their characteristics, many municipalities have adopted cluster ordinances. Now, cluster ordinances are excellent. They should be used. But if you take a cluster ordinance and you don't individually look at and identify the yield of each property, it enables a tract of land with environmentally sensitive features to take the development, put it on the upland cluster, and get the same yield for the overall tract that they would have had for, the proverbial high and dry piece of land. So the cluster it has become used in New Jersey as a way to exact density and intensity of use uniformly on all properties, regardless of their environmental constraints. So that's my first major recommendation to everyone. And also recognize that when the land use law was enacted, it was the first time they ever required a municipality to have a master plan to support its zoning. And I call it the marriage of the environment and planning, because if you really look at there are two fundamental elements of the master plan: the land use element and the housing element. And then, of course, there's the goals and objectives, which you must also articulate. If you look at the land use element, which is the foundation of planning, it is tied to environmental features. How many times have you seen a master plan that says, oh, the soils on this property in this area are Manahawk and muck. They're not good for development. We're going to have very, very low density. They don't do what they are allowed to do. What they are really, they should be doing in order to determine what is the density and the intensity of use that will be allowed. It is the unfortunate race for ratables, which often drives that, but that race for ratables can often end up being the onerous responsibility of the town at the end of the day, because they end up getting development, not realizing the fiscal impacts of the development that they're allowing, particularly when it starts to flood everybody in town. So the tools are there. It's implementing the tools that is the challenge to everyone. And, but they are there and they can be used. And similarly, plan development options. So combining the individual limitation lot by lot through the definition of density and floor area ratio, combining that with really well written plan development and cluster ordinances, you can accommodate development in a way that is beneficial to the community and that doesn't destroy the essential resources that you need in order to survive down into the future. So those are the tools that I think are unfortunately very sadly ignored. So towns have just thinking that they are doing the right thing. They have put these cluster and ordinances into effect, and they haven't recognized that what they're really doing is letting sensitive pieces of land get a lot more density because they can't build on them as they may choose to do because of, various, the freshwater wetlands, the Wetlands Act of 1970, CAFRA, which unfortunately has, CAFRA has its limitations in terms of how it has been implemented more than how it was devised to be. But they can take all these things that they can't build on and then just push all the density and all the stormwater into the areas of the site that are sensitive. And, that is certainly, a problematic issue. And, but it can be avoided by a careful look at the ordinance. So the next thing is that those two issues of density and floor area ratio, they can be incorporated right through definitions. So one should never forget the power of a definition and the impact of a definition. One of the best examples that I see as being so problematic is what happened with this flourishing of huge warehouses throughout the state of New Jersey. And there was obviously significant outcry in many communities. They are extremely, they're not just nice, quiet little buildings where you put your material and you leave it there. Warehouses that we see now in the internet world are just diametrically opposed to what warehouses used to be. So you had a definition of a warehouse, and now all of a sudden you're getting a high cube warehouse with 24-hour truck business in and out. And it's because the definitions allowed them to have it. And, that controversial and very well recognized case in Sparta, where the members of the board who had lobbied to become members of the board in order to fight warehouse development ended up getting disqualified from participating because of their outspoken opposition to the warehouse, which was permitted by the definition. You don't want to be in a situation where you don't know what your ordinance really allows to take place. So if you sit on a local planning or zoning board, or if you're just a community member, inform yourself about what is really allowed and what may be the remaining open space in your community. And find a way, if you're not currently in a position to be able to influence that through the process of the land use boards, then take the simple step of approaching the mayor and asking to be placed on an a citizens advisory committee, so that you can begin the process of reviewing the ordinances and coming up with a solution. Very proudly, I can say that it was about 20 some years ago that maybe more, that I began working for Hopewell Township because they were faced with massive development that they had not anticipated would affect them in the manner that it was. And we worked cooperatively with the community, with the boards, and put into place really meaningful protections for the community that recognize the environmental constraints, were fully bottomed with scientific analysis and professional perspectives. And it became a very important manner of saving the mountain areas and the valley areas in that community that were just being devastated with overdevelopment. You have to do it before the application is filed. New Jersey now has in the municipal land use law, a provision that if someone files an application, the zoning ordinance affecting that property cannot be changed. It can be changed to benefit the applicant, but not to reduce or negatively affect the applicant. So if you gee, I didn't know we could have this huge warehouse here. You should know that now. You should know that by going through your ordinances and taking the necessary steps to be able to address these potential threats. One of the ones that I have recently became aware of was the AI facilities. I had no idea that they are such a drain on the environment, such a drain on water resources, such a tremendous user of utilities, and that they leave a constant noise level, that has been negatively affecting communities. So what do they call it when it comes in? Does it fit in any of your business zone definitions? Is it something that you may be able to avoid or perhaps do as a conditional use? Because I don't know how many of you sit on planning and zoning boards, and they have to have what they call a will serve letter from utilities, that there's enough water. Okay. Well, I hope you don't trust the idea that a utility company supplying water is going to tell a developer that we can't give you water. They don't say, we have a statewide drought and we don't have enough water. They never say that. So these are parts of what you need to be able to make sure you build in, because what is your development potential? You have the power to regulate that. There's no question, but you do have the power to do that. So take advantage of that power. And don't allow it to be lost through development that has, just taken advantage of whatever provisions you have in your ordinance. I really believe that in many respects, the ability to have local home rule, and I call it enlightened home rule. And that's where every citizen really comes into play in affecting how your community is going to go forward. You move there for a reason. You stay there for a reason. How do you manage to keep it so that it is not overwhelmed? It's not that you can stop everything, but rather that you can assure that what is developed in the future is going to be taking into account what the real full growth, and that is another new component of what the master plan allows you to do through the municipal land use law, is that you're supposed to be looking at your, what would happen at full growth of your community, and can you really accommodate it through the provisions that you have in your existing ordinance. One of the common complaints you hear is traffic. Obviously, New Jersey is just riddled with traffic jams. It's kind of the nature of the state. I always say, if you went from point A to point B in 2005 and it took you 10 minutes, you had 5 minutes on the next year. We haven't really looked at traffic because there's so many components to it. You have the state roads, which the municipality doesn't control. You have the county roads, which the municipality doesn't control. And then you have congestion. But if you propose a use that's going to have too much traffic for the road system, and you have allowed that use in your ordinance, the court cases say you cannot stop it because of traffic. By allowing the use, you have recognized as a community that you can accommodate the traffic. So all in all, it is a challenging body of law, but it does enable municipalities to do the right thing and control growth as the municipal land use law authorizes. And the authorizations in the law are broad if properly implemented and properly put into place. You know, for years, and like I said, I mean, the land use law went into effect in 75, 2003. The Supreme Court adopted the decisions in Rumson and Ferrara. And until that point, people operated under the mistaken belief that you could not change density from the definition in the statute, which says the number of dwelling units per acre, not the number of dwelling units per buildable acre, but per acre. So it changed, and that's a very, very significant change. Now, I know that Mike Sinkovich is going to address stormwater, but you know, and again, this is one of these things where there was a significant change in the law with the adoption of the residential site improvement standards, and that change then made municipalities often feel that their hands were tied behind their back, and they're not really. And I'm sure Mike is going to address that. So, you know, all in all, I believe that land use law in New Jersey affords municipalities with the power to protect their community, but that we as citizens have the ultimate obligation of making certain that those in government that are responsible for enacting and implementing the laws recognize these powers, implement these powers, and take the care that is necessary to protect the community. And combining the variety of tools that become available, you can do something in the future, but you can't do it after the application is filed. You can't wait. So maybe everyone's New Year's resolution could be to look over what your ordinance provides, what your master plan calls for, and see whether or not there's any interest in opening up the process to be sensitive to the environment, sensitive to the land that is being regulated, and that will protect the future of your community. So I know we're going to hold questions to the end, and I think I've said everything I need to say at this point. Hello?
Thank you very much, Michelle. That was amazing. And as Mike is bringing up, and I have to stop sharing for a second, as Mike is bringing up his slides, just Michelle, and you said a lot of this, but, you know, bringing home a couple points. One, definitions that have been in municipal ordinances for years and years, especially, for example, warehouses, those definitions may no longer reflect the realities of what is happening today. So going back and looking at those definitions and updating them to reflect current trends is important. And then one things I always hear when I do planning board meetings, well, the township zoned for it, so it must be okay. They must have, you know, considered the environmental aspects, the environmental constraints. And that's not necessarily true, is it, Michelle?
I'm sorry, what did you say, Mike? I didn't quite
So,
get it.
yeah, so when you go to applications and you argue over the density, or you argue over, well, this doesn't really fit the zone, and the applicants always said, well, it's zoned for it. So the planning board, the township has already considered the environmental constraints of a particular site and have allowed it. So I should be allowed to do what I want. The zoning is broad brush. It's not lot by lot in many cases.
Correct.
So, you know, your recommendations of pulling out sensitive areas from impervious cover, or the floor area ratios, really start to do that. The stream corridor ordinances start to do that. But that's always a argument. Well, it's zoned for it, so the environmental constraints really don't matter. And
Right, that's what you hear.
yeah, and that's
Yeah.
just not true. So
Well, it is not true, but if the municipality has zoned sites and has not taken into account adjusting the density, the floor area ratio, the coverage requirements based on the environmentally sensitive features, then you have to live with the ordinance that they have passed. If they want to be totally pro-development and not think about the environment, they have the right to do that, unfortunately.
yep. All right, thank you.
Okay.
So Mike, go ahead. Appreciate it.
Thanks, Mike. Is my screen shared? Always concerned.
Yes, it is.
Awesome. Thank you. Well, thank you again, Mike and the Watershed Institute for inviting me to be here today. And thanks to Mark and Michelle for some really great information. I'll do my best to follow that up. What I'm hoping to do today is just give a sort of a brief overview of municipal ordinances. It's going to be a little bit of history, going over a little bit of the laws, and then diving into a couple different aspects like tree protection and stormwater management. Basically a smorgasbord of municipal environmental ordinances. So starting with that, hold on. The first overview I just wanted to state, as I'm sure everyone on this call or this presentation understands, the New Jersey Department of Environmental Protection is our, of course, environmental regulatory agency in the state. And they have regulations that deal with all aspects of the environment, from clean water, clean air, environmental remediation, site remediation, to land use permitting and stormwater management and things like that. The important, I think, theme of a lot of what I think we're all saying today is the DEP really sets the baseline for a lot of these environmental protections. And, the goal and the hope is municipalities, take it upon themselves in appropriate circumstances to, strengthen or maybe raise the floor of what the environmental protection is in that municipality. Of course, as I said, the DEP sets the floor in many of these instances, but the hope is that a municipality, takes it one step further. And sort of just stepping back, there's really two methods for what we're talking about that I understand that your municipality has to control the environment, if you will, in their towns. That's both the municipality's land use regulation or zoning power under the municipal land use law, which is, what Michelle just dove into in great detail. And then, of course, the municipality's general police power, which I'm going to talk about in a second. So zoning power, municipal zoning ordinances and their requirements, they must advance the municipal land use law or the MLUL's broad goals, which are defined in the statute. One specific purpose that I highlighted, because it's really what we're talking about when you're dealing with the environment, is the requirement or the purpose to encourage municipal action to guide appropriate use or development of lands in the state in a manner which will promote public health, safety, morals, and general welfare. And a lot of what we're talking about with environmental protection is, the importance and the goal of protecting, public health and safety and the general welfare. So the MLUL defines what a zoning ordinance may specifically regulate. There's a list, I'm not going to read them. There's a list in the statute of, it's actually in subsection 65 of the MLUL that goes through, it's subsections A through L of what a land use or a zoning ordinance may include or deal with. Zoning power, the Supreme Court in Pheasant Bridge Corporation versus the Township of Warren in 2001 explained that a zoning ordinance has a strong presumption of validity. so long as it's consistent with fundamental principles of zoning and of the zoning statute and of the MLUL. So it must have a real and substantial relation to the object sought to be obtained. And the reason all of this is important is because when you're crafting an ordinance, if you are a municipality, if you are in charge or working on or wanting, to propose, as Michelle suggested, as a member of the public to get active and try to, help your town do something. It's important with zoning regulations that they really need to have a substantial connection to an objective sought under the MLUL. Otherwise, they're going to be subject to challenge, maybe, by builders. We've seen that a lot. I know Mike and I, as I'll get into a little bit later on, dealt with cases in which, builders, for example, were challenging enhanced stormwater ordinances, saying that they go beyond what's allowed under the zoning power. So the second, municipal power that I explained is the municipalities have a police power. It enables any municipality may make, and this is just an excerpt, or enforce other ordinances that are not contrary to the laws of the state, as they may deem necessary and proper in order to protect persons and property and for the preservation of public health, safety, and welfare in its inhabitants. So again, why am I talking about this? Why am I talking about police powers? It's because it gives a town another mechanism to focus on the preservation of public health and safety and welfare, but take it outside the box of the zoning regulation and focus more on these police powers. And I'm going to discuss a case study in which that was utilized for stormwater management in New Jersey. But before I do that, I thought, I always like a little history lesson. Tree protection in New Jersey. I think anyone who thinks of environmentalists, I think, us environmentalists are called tree huggers. Maybe for a reason, and that's because tree protection really is one of the earliest examples of not only environmental protection, but municipal environmental protection in New Jersey. In 1925, really, municipal shade tree advocates organized the New Jersey Federation of Shade Tree Commissions, and it promoted community forestry and the governance of public trees, essentially, trees on public lands. And even earlier than that, in the late 1890s, New Jersey statutes permitted municipal officials, municipal government to plant, maintain, protect trees in public spaces. But the question when you're thinking about this is, okay, public makes sense, but what about private lands? And, environmental awareness increased nationwide in the 1970s and 1980s. For those that didn't get Mike's trivia question, I'll spill the beans. 1972 was the year that the Federal Clean Water Act was enacted. 1970 was the year, I believe, that the EPA was enacted. Environmental protection for people like me have been around my whole life, but in reality, it's a really new concept. And environmental awareness, as I just said, began to increase during these periods of time. And that's when, in this particular context, municipalities began expanding ordinances beyond public trees or street trees to try to regulate tree removal on private property. And that's in some instances where municipalities started to run into trouble. But there was a big New Jersey Supreme Court case in 2009, and this is where I'm going to tie in our police powers with the environmental protection, at least at the start. The township of Jackson, over near Six Flags, adopted an ordinance regulating the removal of trees on private property. Ordinances that you probably all know of, because I think they're in most, if not every, I think they're in every town now in the state of New Jersey. And it required property owners to replace trees of certain size, of certain characteristics that were removed, and if that was not feasible, they were required to pay into a municipal fund dedicated to planting trees, as we see a lot in applications throughout the state. The Builders Association argued that it violated the MLUL, that it didn't, this specific requirement was in fact regulating land use, and these trees and tree protection was not one of those, enumerated zoning ordinance provisions that are allowed within the MLUL. However, the court held that the ordinance, although it touches on the use of land, the ordinance is not a planning or zoning initiative that necessarily implicates the MLUL. And this is where the court made the distinction. They said that there's a number of ordinances, such as health codes, building codes, and laws regulating the operation of particular businesses that touch on the use of land, but are not within planning and zoning concerns of the MLUL. And those ordinances are enacted pursuant to that general police power, and they apply to everyone. And that's what the court held. That's what the nature of tree removal ordinance at issue here. That's what it was. It was more of a generic environmental regulation and not a planning or zoning initiative. And this is interesting, at least in my mind, because in a way, I think this opens the door to other environmental regulation in a municipality, which of course, almost all environmental regulation touches on the use of land, but the court has now held that the police powers can be used for quote unquote generic environmental regulation. So it's again another way to, as Michelle said, just because there are certain prohibitions in the residential site improvement standards or the MLUL, there is, I don't even want to say a way around it. There's just another mechanism in which, that's available to a municipality to protect the environment. So anyway, tree protection ordinances in brief, their prevalence, as I mentioned before, there's often permit requirements for removing significant trees. There's protections during construction. There's replacement requirements. Many towns have definitions of landmark trees, these beautiful old growth trees that just can't be removed under any circumstances or only under limited circumstances. And dovetailing this now back to the environment more specifically, in 2022, I believe that's correct, the DEP introduced a new requirement that municipalities with MS4 permits, which I'll explain what those are in a minute, need to adopt ordinances governing tree removal and replacement, because trees, like all vegetation, just like what Mark spoke about at the start of this seminar, they help manage stormwater, they help reduce runoff, and they help resilience to climate change. So now it is a requirement to have these tree removal, tree protection ordinances throughout the state. So I want to talk about now, shift my focus to stormwater management. I'm not going to go through all of this in detail. I know, we don't have a ton of time, but stormwater management, Mark touched on this or delved into this. Why do we care, right? That graphic there is a graphic I love. It's the water cycle. It's the idea that, what happens, when it rains, rain goes into the ground, it goes into streams, it infiltrates, into groundwater, ends up back, into bodies of water, evaporates, and then rains again. And it's just this huge cycle. And impervious surfaces disrupt that cycle. They prevent rainwater from infiltrating into the ground. There's also other problems. Obviously, runoff can be contaminated with a whole host of things like petroleum, salt, other chemicals. And as we all know, we've all seen in this state, excessive runoff can cause flooding, property damage, a whole bunch of other problems. So what's the solution? The solution is to have appropriate stormwater management that, both restores the water cycle, but also ensures adequate protections to flooding, property damage, and things of that nature. The background, which I'm not going to dive into in great detail, but, stormwater management really originates from the Clean Water Act, the 1972 year that it started. And stormwater and storm sewers are deemed point sources that you need to have a permit for. And these permits are called these MS4 permits. Those are municipal separate storm sewer permits. Municipalities need to have one, and one of the requirements they need to have one for the most part. There's some nuances to it when a town or a city has a combined storm and sanitary sewer system, but for the most part, municipalities need to have these MS4 permits. And one of the requirements of these permits is that the municipality adopt a municipal stormwater ordinance. The stormwater ordinance has a number of requirements. One of the requirements is to control aspects of residential development and redevelopment projects that are not preempted by the residential site improvement standards. And I'm going to touch on that in 1 second. They, of course, have to control stormwater from non-residential developments and redevelopment projects in accordance with the state stormwater regs. They're supposed to set forth special area standards approved by the Site Improvement Advisory Board. The preemption of by RSIS is a complicated topic that we could probably have a whole hour and a half. We might have already had a whole hour and a half seminar about, and that is the residential site improvement standards, which are sort of incorporated into the municipal land use law, are supposedly set the maximum standards for residential development. And the stormwater requirements under the RSIS are for major developments. Many of you probably know this. A major development essentially is any development that's going to disturb 1 acre or more of land, increase impervious coverage by 1/4 of an acre, and there's some other definitions of major development as well. But the problem with this RSIS preemption issue, maybe, and I don't necessarily agree with what I'm about to say, but the problem that's been pointed out with a lot of people is that, well, the problem if you say that only major development can be regulated, residential development can be regulated by these stormwater ordinances, means that many towns in the state, like Princeton, where I am, like other, very suburban or urban towns, you're not putting a lot of 1 acre or more developments in. You're rebuilding houses. You're building houses. You're missing sort of the root cause of a lot of these stormwater problems, and municipalities in some manner feel, that they're unable to adequately address stormwater for those smaller projects. And that's part of the reason why I brought up the police powers, because the police powers, create sort of another way in which a town can regulate stormwater. That's what's being done, for example, in Princeton, where I live. And Princeton has a enhanced stormwater ordinance that regulates not only major developments and the things that are listed here, but also regulates minor development, smaller residential development, which is prevalent because smaller, older houses are being knocked down and being reconstructed with the larger structures, and absent an ability to require some sort of stormwater management, you're just not really solving the flooding problem that may exist. So the workaround that they've done, to the extent that I understand it, is not only did they incorporate it within their zoning ordinance with the focus of tying it to the purposes of the MLUL, but also utilize the police powers that are afforded to municipalities to make it a more quote unquote generic environmental regulation that focuses on the protection of welfare, and it's specifically tied to certain elements of a redevelopment, like the size of the project, the addition of impervious coverage, etc. So far they've from what I understand, it's been up and running for a number of years now, and it's been successfully implemented within the municipality. Very briefly, we could have, and again, a 4-hour conversation about what stormwater management is, but there's really 3 key prongs to what it is. And that's stormwater quality, which is reducing pollutants, stormwater quantity, which is controlling runoff and volume, and then stormwater recharge, which is, what I talked about before, trying to get this water back into the ground where it belongs. And controlling runoff rates, Mark touched on this. A lot of what's done or historically is you use these large detention basins or these large infiltration basins in which, through a series of mathematical calculations, you figure out how big it's supposed to be. You direct all your water, into that area, and it's supposed to reduce the risk of flood because you're controlling the quantity of water that's leaving a site, and you're letting it to either, naturally infiltrate or at least slowly move out through a stormwater system. However, the DEP recently, in 2021, required more natural type stormwater management mechanisms called green infrastructure, in which you're supposed to, the goal is to move away from those large basins, which people, may not maintain and end up fishing in, and, use bioretention and rain gardens and swales or porous pavement, things that are, geared towards getting this water back into the ground while also controlling flooding and pollutants and things like that. I wanted to touch on just quickly, there is one other aspect that many of you who deal with municipal boards and municipal projects and stormwater management is, a case that our office cites a lot, and I know is used throughout the state, Safe Hamilton Open Space versus Hamilton. That was a situation where a project was approved based off of the need for the applicant to get a general permit from the DEP. The applicant at the time was asserting that the DEP would review the stormwater and therefore the board didn't have to do it. This case stood for the proposition and confirmed that municipal land use boards are required to ensure compliance with stormwater management. You can't just defer it to the DEP, and assume that whatever permit they're trying to get will analyze the state standards for stormwater management. This is also sort of dovetails with another comment, which is, if you're a municipality and you're hopefully adopting an enhanced stormwater management ordinance, you as a municipality clearly have a duty, your land use board, to ensure compliance, because your, stormwater management ordinance is even more protective than that of the state. And therefore, even if the state were to look at a permit, and maybe under certain circumstances, like wetlands permits, they do review stormwater management, but it just confirms, that the local level is really where we can ensure that stormwater management is done right. I discussed the Princeton case already, but what I wanted to do in just the last 2 or 3 minutes I'm going to talk before we open it to questions is, there are other examples of municipal environmental ordinances and requirements that, that can be utilized and are really effective in helping, preserve this green environment that we all want. Mark hit on one. I was going to use another town as an example, but the stream corridor ordinance in Hillsborough, they have an ordinance that requires, I believe, buffers of 150 feet in both directions from a stream channel and its banks. This is another example of, a town, having a ordinance that's more protective than that of the DEP. Typically, a general standard for a buffer from, a stream corridor is 50 feet, for example. Not in all cases, but, in general, 50 feet, that's a DEP requirement. Well, Hillsborough, takes this approach that they have, even further requirements, and they're doing this, of course, to protect, flooding, to protect the public health and safety of the town. Steep slopes, that's another great example of an environmental protection ordinance, ensuring, both, the health of projects, but also just, making sure that these natural landscapes, maintain, the way that they are in their natural state. A third one I wanted to mention, because I think it's important and it often gets lost in a lot of land use applications that I'm involved in, and that is environmental impact statements. Most towns have a requirement under certain circumstances to submit an environmental impact statement. They're comprehensive documents that go through a whole host of, things like what are your impacts to wetlands? What are your impacts to threatened endangered species? And how are you going to mitigate them? What are the noise pollution issues, the air pollution issues, things like that. My biggest, I guess, pet peeve, if you will, with these EISs is that they're often submitted, but then you never have any, you never have the author testify to the contents of the EIS when they're done incorrectly, or they're sort of just, done in a rushed fashion. There's a limited ability to challenge them by the public. I think the EIS is a really important way, and the reason for it gives a town or a municipality the ability to look at a project on a holistic view in terms of the environment. But I feel oftentimes they're an afterthought on a project, and something for anyone on this presentation that's involved in municipal government. I urge you to make this environmental impact statement at least more of an important focus in these development projects, because I think it's a great tool. So, in speaking of resources and tools, there are a lot of model ordinances. Well, not a lot. There are a number of very good resources online, starting, of course, with the Watershed Institute, that has model ordinances out there that you can look at for not only stormwater or tree protection, but all of these things that we touched on and more. A few examples of the Watershed Institute: New Jersey Future, Sustainable New Jersey, the Association of New Jersey Environmental Commissions, and the NJDEP. So, if you're interested in the topic, if you're involved in government, if you're a member of the public that wants to get involved, I suggest you take a look at some of these websites and, take a look at some of these model ordinances. So with that, I think I spoke enough. I appreciate your, listening to us and attending. And I, again, wanted to thank Mike and the Watershed Institute for inviting me.
Thank you very much, Mike. I appreciate that, and thank you for review. So we have some time for Q&A. So please put those in there. And let me start off with, so here's a good question. Can municipalities collaborate to develop linked ordinances? Are there state rules, or is that a problem with home rule? Anyone want to take that?
I'll try my hand at it.
All right.
I think that the one of the goals of the land use law, and there are cases that address this as well, that municipalities should be cooperating, because the environment doesn't stop at the town's boundary or the other impacts of any land uses. So I think that it would be very wise to do so. When they go to adopt a master plan or amend an ordinance, they have to notify the clerk of the adjacent towns. I think a collaborative undertaking is really essential.
Yeah, absolutely, Michelle. And I will add to that the stormwater rules. Not that anyone has ever implemented this aspect of the stormwater rules, actually contemplates regional stormwater control ordinances. I'm not aware of any town or towns that have done that, but towns could join together to develop a regional stormwater control ordinance, for example, for a watershed that has issues. And I will also note that the ongoing watershed improvement plans that towns have to develop under the MS4 permit, also DEP is encouraging towns to do that on a regional basis. So not necessarily ordinances, but another regional approach that towns can take and that we have been promoting. And we have 3 regional approaches currently taking place and looking to do a 4th. Good question on affordable housing, because that's always an issue, as Mark pointed out. Sometimes affordable housing is promoted in the detriment to the environment, but right now the affordable housing ratios 1 to 3, it's actually 1 to 4, have increased housing units needed to extreme numbers. Are you aware of any municipalities that have created more creative ordinances or financial ways to build more than just 1 unit to meet those numbers? So yeah, I mean, it's not necessarily the affordable housing that's causing environmental degradation. It's just the overall number of housing units needed, that 1 to 4, to do the developments. I know some towns are doing 100% affordable, but I don't know if others have thoughts other than not waiving your environmental standards to do it. And I know the various Mount Laurel cases have stated that it's not the environment versus the affordable housing, and you're not supposed to sacrifice the environment for it, but I think that is sometimes lost in these plans. Yeah, other than sort of towns financing and doing the 100% affordable, I'm not sure I'm aware of anything. Michelle, Mike, Mark?
I'm familiar with something that Tom's River just did. I don't know the details of it, but they took existing housing apartment complexes that they had, and they made arrangements with the owners of those units to provide for a certain percentage of them to meet the affordability requirements of the Fair Housing Act. So they took, and really, and it relates back to that whole credits without controls issue. A lot of towns opened themselves to development, which allowed over the many years to accommodate low and moderate income housing. However, state didn't recognize it. So now they basically implemented what would be, they used to call credits without controls. They have credits with controls now. They did it through negotiating with some of the developers. Thought it was a great idea.
Interesting.
Yeah.
And the state plan that was recently adopted really is encouraging towns to look at redevelopment. We have a lot of office parks. We allow a lot of shopping centers that are underutilized or vacant. And, as we rapidly approach full build out, our housing needs are going to have to look at redevelopment to these underutilized properties versus virgin land. All right. Question on, has anyone had any experience implementing successful ordinances for pesticide runoff from golf courses? I know there are rules.
Mike Sinkovich, you should answer this one because you made sure to point out, don't forget the police power.
Right. Yeah. I mean, I haven't seen any specific examples. There may be some out there. As somebody who loves the environment and also loves golf, it's always a conflict in my heart. But no, yeah, I think something like the police powers could be used to do that. And it is an important feature. I mean, unfortunately, you're right. I mean, golf courses use, incredible amounts of pesticides and are often very close to or on stream corridors and things of that nature. So I'm not sure if that was an answer, but I think that's a really good thought and something, important to look into.
I will point out that the Watershed Institute, a few others, have a river-friendly program. There's a river-friendly golf course, which may address some best practices for that. So take a look at that. And before I forgot, because I've forgotten, your second code for your attorneys is STREAM, STREAM, because we'd like to keep those healthy and safe. STREAM. All right. We are just about at time. I will also mention Cheryl Reardon from ANJAC mentioned that municipalities really need to make sure their environmental resource inventory is up to date. Make sure it's reflecting current mapping and making them available online. I mean, those are a really good place for towns to start to understand their environmental constraints. So that is absolutely true. And I'm going to close this out with a couple little things. One, and I think this was said, but if it wasn't, I want to make a very fine point. All of our environmental regulations to date have assumed that we can degrade our environment. We're just trying to reduce that degradation. They have not really, our flood hazard rules, our wetlands rules, or, all of our stormwater rules is how do we minimize the degradation? It's not how do we stop that degradation, not how we prevent the degradation, just minimize it. Our watershed improvement plans through the MS4 permit is our first time when we're really starting to figure out, okay, how do we reverse? What do towns have to do in reversing those impacts? And ordinances, while not called for in these watershed improvement plans, are municipalities' opportunities to actually put in place strengthened ordinances, strengthened protection, so we don't do the degradation, so that towns don't have to develop projects to fix what they could have prevented as we go forward. That's my huge advocacy soapbox. And since I'm advocacy director, I get to do that. And that's unfortunate, but the Clean Water Act, as Mark said, restore and enhance our waterways. And that is what we are supposed to be doing. So with that, I appreciate it. Let me just do a couple closing slides. I appreciate our speakers, Michelle and Mike and Mark, for your expertise and your time. So the Watershed Institute, this is our first of several Technical Fridays. Our Assistant Director of Science is doing a series of Salt Watch webinars and programs next week. More information at wintersaltweek.org, all next week. As I mentioned, we have Technical Fridays. We are pulling together with the recently adopted Resilient Environments and Landscapes rule, a webinar in April to talk about what those rules mean and including what those rules mean for stormwater. There is a webinar on May 8th on the best benefits of restoration. Restoration is going to be, I think, more and more important in New Jersey than it has ever been. And a company in Pennsylvania has been doing a lot of it for their DOT, talking about those successes. So stay tuned for our Technical Fridays this year. And then, our Watershed Conference coming up in February. Registration is open and information on our agenda. So if you've enjoyed these series, please join us on February 26th and 27th for the 9th Annual Watershed Conference. Again, as I mentioned, all these materials will be sent after the webinar in a week or two. So be on the lookout for an email from Priscilla. And again, speakers, Mike, Mark, and Michelle, thank you very much. To the audience, thank you very much for your attendance. And I look forward to seeing you all in a couple weeks at the conference. Thank you very much.
Thank you very much.